Hello friends, welcome back. Now let us see return of plaint and rejection of plaint. This is dealt by Order 7, Rules 10, 10A and 10B of Civil Rules of Practice. Rejection of plaint is dealt by Order 7, Rule 11. There are so many clauses in Rule 11. Okay? Friends, after you presented the plaint, the court may return it for compliances. For example, you have not paid the proper court fee, then it can return it. And you have not supplied the proper copies of number of plaints in commensuration with the number of defendants. Okay? Like that. And the plaint can also be returned as per section 10 if it is found that the suit is filed in the wrong court. The suit should have been filed in another court. Then at any stage of the suit, the civil court can return the plaint, directing the plaintiff to present the plaint in so and so court. And this is there in section 10. 10A envisages that the civil court must set a date and direct both the parties to appear before the court as it is going to transfer the suit to that court. Okay? And the 10B relating to commercial matters. Commercial Courts Act matters. Okay? Rejection of plaint. There are 5 or 6 clauses in Rule 4, and number A is the court can reject the plaint if the plaint does not disclose the cause of action. Okay. Yeah, other B, C, normally courts will not reject this. E, reject the plaint on the basing on these defects. But another defect is crucial. This one, D, Order 7, Rule 11, Clause D, says that on reading of the plaint, if it is found that the suit is barred by any law, then the court can reject the plaint. Okay? And when once the court rejects the plaint, it comes under the definition of decree as defined under section 2, subsection 2 of CPC. The remedy is appeal suit. You have to file appeal challenging the same, or you can file another fresh suit under Order 7, Rule 14 of CPC, which says that when your plaint is rejected, you can file fresh suit on the same cause of action. Okay? Here, friends, if the plaint does not disclose the cause of action, then the plaint should be rejected. It is the principle. Normally, how can you say that the plaint does not disclose the cause of action? At the time of hearing the applications for rejection of plaint for not disclosing the cause of action, the advocates normally mislead the civil courts, only picking the cause of action paragraph, saying that there are defects in the para of cause of action. No, the High Courts and Honorable Supreme Court time and again reiterated that cause of action should be ascertained by reading the whole plaint. After reading the whole plaint, if the court comes to a conclusion that the plaint does not disclose the cause of action, then only it can reject the plaint. Okay? Likewise, barred by any law. For example, if there is express bar, the plaint shall be rejected. If there is implied bar, the plaint shall be rejected. If the suit is barred by limitation, the plaint will not be rejected. The Honorable Supreme Court and various High Courts stated that if it is alleged that the plaint is barred by limitation, the court cannot reject the plaint on the sole ground that the question of limitation is a mixed question of facts and law. And this barred by law means only law. Okay, you get the point? Therefore, when the defendant takes the objection that the suit is barred by limitation of law, the court shall not reject the plaint. Instead, it shall continue to try the suit. Okay, you get the point? If there is an express bar or any other bar, for example, clear cut, it is on the face of the record that it is barred by limitation, it can dismiss the suit under Section 3 of Limitation Act. If it is some Hindu charitable property, it is barred by limitation. It is barred by the Hindu Religious and Institutions Act. Okay? When it is barred, when the suit is in relating to Surface Act, certainly it is barred by limitation. The court can reject your claim. Okay? Friends, and the last aspect relating to the plaint, not last, but it is some kind of okay. Now, since we are dealing with the plaint, I thought that it would be appropriate to discuss about the concepts of res sub judice, Section 10 of CPC, and the concept of res judicata, Section 11 of CPC. My dear friends, Section 10 of CPC, the heading shows that it is stay of suits. What does it mean? That if similar suit between the same parties is pending before any other court or the Supreme Court or the court established by central government out of India, then the civil court shall stay the suit before it. Therefore, so many advocates, what they do is, they file an application before the district judge if the matter is within the district, or before the High Court if the matter is before different district courts, before the Supreme Court if the matter is if the matter is pending before different states, courts of different states, to transfer the suit pending in another court before this court where the present suit is pending for clubbing of both the suits or for common trial. Okay? This is called the concept of res sub judice. Okay, res sub judicata means, friends, if any subject matter, if already a suit has been filed by a plaintiff against the defendants in respect of a particular subject matter between the same parties and the suit has been decided, or any issue has been substantially decided in the earlier suit, subsequent suit shall not be tried by the civil court. You get the point? If, for example, A files a suit against B in respect of X property or X relief, and it was decided and disposed of long back, say in the year 2019, and again either of these parties can't bring another suit before the civil court, okay, in respect of the same subject matter, either A or his legal representatives, either B or his legal representatives. That is the principle of res judicata. Friends, this principle will be asked in the JCJ's, competitive test, junior civil justice competitive test, and other competitive tests of lawyers, compulsory. And another concept is there. Explanation 4 to section 11 says that any ground or plea which ought to have been taken in the previous suit shall be taken, shall be deemed to have been taken in the previous suit only. You can't file subsequent and subsequent suit and claim that I omitted to take this ground in the earlier suit, therefore I am taking this new ground in this subsequent suit, I am filing this subsequent suit. No, that is not accepted. If you had the opportunity to take the plea or ground in the earlier suit, both as a plaintiff or defendant, it is deemed that you have taken that plea in the previous suit itself. This is called constructive res judicata. Okay, friends? Okay, another parties, wrong parties, correct parties, misgender of parties, or non-gender of parties are not fatal to any suit. The court can suo motu on application remove any plaintiff or defendant or add any plaintiff or defendant as per the provisions of Order 1. Okay? Order 1 Rule 8 or 9 says that, proviso to this misgender and non-gender concept, says that nothing in this rule shall apply to non-gender of necessary party. If a party is necessary to a proceedings, if that party, necessary party was not added in the suit, then the suit is fatal and it shall fail. For example, in partition suits, normally the plaintiffs don't add their sisters. Male plaintiffs don't add their defendant sisters in the suit, claiming that they were given proper dowry and they are not entitled to any share in the ancestral property. And this omission to join this sister will fail the suit of the plaintiffs. Certainly, there is no doubt. This concept, non-gender of necessary party, is fatal to the case, is 100% applicable to the suits for partition. Okay? Another, in a suit for specific performance, you file suit for specific performance against the defendant who sold the property to you. And in the meanwhile, before he executes a registered sale deed in your favor, he sells away the property to some third party who becomes the subsequent purchaser. And the Honorable Supreme Court says that you should add the subsequent purchaser for proper adjudication of the suit for specific performance. While adding the subsequent purchaser in the suit for specific performance, you need not seek for cancellation of subsequent registered sale deed executed by the defendant in favor of the subsequent purchaser. The Honorable Supreme Court further said that it is suffice to seek a direction from the court that subsequent purchaser be directed to be joining with the original vendor to execute a resale sale deed in favor of the plaintiff. Okay, friends, that's all for now. Thank you very much. If you like this video, please subscribe for such videos. If you like this video, please like the video by pressing thumb button. And you want to receive further notification in respect of my classes, kindly press bell icon. Thank you.